So this is the last chapter that we'll cover for this module and the last that we'll formally cover in the class this semester. Chapter 33, Agency Formation and Duties. So we've got a number of learning objectives here. None of them are terribly long, but 1 through 3 will be in the first quiz, 4 through 6 in the second quiz. Case 1. Brian Puryear is an employee of Wellborn Industrial Systems Incorporated, located in Little Rock, Arkansas. Times are tough at Wellborn. The company's rank-and-file workers have not had a raise in 4 years. Despite the federal government's assertions that inflation is under control, Puryear knows that prices for goods and services keep rising, and he desperately needs to make up for the difference. Puryear has been searching the internet for part-time jobs in Little Rock. He notices that a security guard position is available at a local manufacturing plant. The security job is Monday through Friday from 8 p.m. until 2 a.m. His job at Wellborn is Monday through Friday from 8 a.m. until 5 p.m. Would Brian Puryear violate his duty of loyalty to Wellborn Industrial Systems, Inc. if he accepted the part-time security position? From an ethical standpoint, should Brian notify Wellborn of his intentions and secure Wellborn's approval before accepting the security guard position? If not from an ethical standpoint, what do you think about legally? Case 2, Robert Newman, attorney at law, just attended a pre-trial conference for a trial scheduled to begin next week. The case, Effingham v. Atwater, involves his client, Jessica Effingham. On September 8, 2009, Effingham sustained serious injuries in an automobile accident when a car driven by Harvey Atwater, the defendant, struck her car from behind. Effingham sustained permanent partial disability as a result of the accident, and Newman believes the case is worth $250,000 for his client's permanent partial disability, pain and suffering, medical expenses, and other compensatory and or consequential damages. During the pretrial conference, Atwater's defense counsel, Gunnar Vader, offered the plaintiff $20,000 in full and final settlement of the Effingham v. Atwater litigation. Vader proclaimed that $20,000 was all of the settlement authority he had, and his client would not pay a penny more to settle the case. Judge Clarence Ginsburg strongly recommended that the plaintiff take the $20,000 settlement offer, but Newman considered the lowball offer to be a personal insult as well as an affront to his client, and he immediately rejected the offer. In rejecting the offer, did Robert Newman violate his professional duty as his client's agent? What do you think? If so, why? What were the factors that caused that to be a violation of his duty? If not, why not? So when we talk about the basics of agency law is basically someone acting on behalf of somebody else. So agency is a relationship between the principal, which is the person being acted for, and the agent who is doing the acting. An agent is someone who is authorized to act for or on the behalf of the principal. Obviously, the principal is the one who hires the agent to represent him or her. Fiduciary is one with duty to act primarily for another person's benefit. So you will often hear the term fiduciary agent when referring to the relationship between an agent and a principal, because the agent owes the principal whatever duty has been contractually negotiated for. So there are many ways that an agency relationship can be created. You've got expressed agency, which is obviously when it is expressly written out or agreed upon orally. You've got a power of attorney, which is a document giving the agent authority to sign legal documents on behalf of the principal. You've got a durable power of attorney, which is basically the same thing as a power of attorney, but it is intended to continue to be effective and or to only begin to be effective if the principal becomes incapacitated. We've got agency by implied authority, which is agency formed by implication through conduct of parties. So basically, if I have an employee that works for me, go out and wearing a uniform that has my company's name on it, and go out and bid for a job, it is implied, if they're in uniform and working for me at the time, that they carry the weight of my agency authority in their negotiation actions. I've got agency by estoppel. That's when an agency relationship is formed by a principal leading a third party to believe that another individual serves as his or her agent, although the principal had actually made no agreement with the purported agent. Again, that's kind of what I was just talking about. Similar to implied authority, where you're basically, even though I guess the real difference between implied authority and estoppel is that implied authority could mean that they actually did have that authority. Agency by estoppel is when you're leading someone to believe that, but absent that belief, there really wouldn't have been any agency there, but you created it by leading them to believe that. We've got agency by ratification. That's when an agency that exists when an individual misrepresents himself or herself as the agent for another party. So again, this is when no agency relationship initially existed, but if in that case the principal accepts the act that was unauthorized, so initially it was an unauthorized act, but if the principal comes in and says, no, I'm okay with that, then that becomes an agency relationship by ratification of the act. For that to take place, an individual must misrepresent himself or herself as the agent for another party. The principal would then accept or ratify the unauthorized act, even though it was unauthorized at the time. For it to take place, the principal has to have complete knowledge of all material facts regarding the contract. And of course, like I said, the principal must ratify not just part of, but all of the agent's act. So the principal is not able to pick and choose components of the action that he or she wants to ratify. We've got different kinds of agency relationships. The just basic general agency relationship is a fiduciary relationship in which the agent acts on behalf of the principal. It's kind of what we already talked about. And we've got some different flavors of that. We've got a principal-agent relationship where, again, this is pretty general, but the employer hires the employee to enter into contracts on behalf of the employer. Parties have agreed that agent will have power to bind the principal in those contracts. So like a sports agent would fall into that category. You've got employer-employee relationships where an employer hires the employee to perform certain tasks. That's the general nature of an employer-employee relationship. The employer has the right to control the conduct of its employees, but that is not only an employer-employee relationship, but is also an agency relationship because the employee would be doing those tasks on behalf of and in the name of the employer. We also have employer-independent contractor relationships where the employer hires people that are not employees, and that's basically an IRS definition of determining what's an employee and what's an independent contractor. But the main difference between independent contractors and employees is how much freedom they have to control the way that the work gets done. If you are basically manipulating the way, not only what you've asked the agent to do, but also the way that they're able to do it, you don't give them like total free reign to do however they want, then you most likely have an employer-employee relationship. Whereas if you hire some outside expert to do something, you say, hey, this is what I need done, go do it, and they're just bringing you back the final product, then that would more likely be an independent contractor relationship. And that's basically what the IRS looks at this point to determine whether someone is properly, because there's a certain number of different tax obligations and issues that arise from how you classify these two. But the IRS determines by basically saying, well, how much control do you exercise in this person's work? I didn't even realize this was the next slide, but yes, this is basically some different ways. All of these have been part of a larger test in the past for the IRS. But again, like I said, the IRS has basically switched to a how much control is exercised by the employer in determining how the job gets done. So for any type of principal-agent relationship, there are certain duties that the principal has, duties to the agent, paying whatever they said they're going to pay, reimbursing for expenses, etc., indemnifying them if some type of liability occurs while they're doing it, cooperate with them to be able to get it done, and provide some type of safe working conditions, or at least not encourage otherwise. Whereas the agent's duties to the principal include loyalty, notification of anything that comes up, like they make a deal on behalf of the principal, they kind of have to tell them about it, performing whatever task that is that they are contracted to perform, obeying what the principal asks them to do. So just because you're given control, that doesn't mean the principal can't tell you to or not to do something as part of the assigned job. And then accounting, not talking about necessarily doing the accounting work, but just accounting for what you have done, keeping some type of record. These rights and duties carry certain rights and remedies. Principals' rights and remedies against the agent if they fall derelict in their responsibilities. You have a constructive trust. You can avoid the contract, and you can request to be indemnified. Agents' rights and remedies against the principal. Normal tort and contract remedies that would arise from actions that are committed on either side are still in play. A demand for the accounting of, if a principal hasn't paid or hasn't paid what the agent thinks that they're owed, they can say, hey, I want to see documentation of that. And of course, they can try to compel specific performance if the principal is not doing what it said it's going to do. All right, now we got hypothetical case 3 here. Maximilian Snell is having a very bad Monday at his pre-owned car dealership, Maximilian Motors. Known countrywide for his eye-catching television advertisements, with staged customers proclaiming, "Thanks a million, Maximilian," Snell is having a difficult time attracting and retaining an effective and reliable sales staff. In fact, not a single salesperson has appeared for work on Monday. The only employee who does show up for work that day is his secretary of 3 years, Daisy Martinez, whose responsibilities include processing tax, title, and tag paperwork. Business is slow that day, with only 2 shoppers appearing on the lot between 8 and 2 p.m. Famished and eager to try out the new Italian restaurant down the street, Snell instructs Martinez to tell any prospective customers he will return at 3:30 p.m. When Snell returns at 3:30, he asks Martinez whether any potential customers visited the lot in his absence. Martinez beams with pride and says, "Why, yes, Max, there was a young couple who came by right after you left. They wanted to buy that red BMW sedan on the front row, and I knew business was slow, so I went ahead and sold it to them. The contract is here on my desk. Aren't you proud of me?" Curious, Snell examines the contract. It describes the red BMW sedan and includes the signatures of both purchasers, as well as Martinez's signature indicating Daisy Martinez on behalf of for Maximilian Motors. The contract price is $21,000. Snell's face reddens as he heads for the car inventory purchase price records on his computer. Computer records reflect that he purchased the car at auction last Wednesday for $28,000, and it is that his established retail price for the car was $31,000. Whoops. Sorry. When he confronts Martinez with the facts, she bursts into tears, saying, "Please don't fire me. I've made a terrible mistake." Martinez is inconsolable, but that is irrelevant to Snell. Through her tears, Martinez indicates that the couple will return at 5:30 p.m. to take possession and ownership of the car. They have gone to their bank to obtain the $21,000. Is Snell legally obligated to sell the car to the couple? If so, what legal standing or what concept requires Snell to have to sell the car at that price? From an ethical standpoint, should the couple agree to pay at least Snell's cost for the car, which is $28,000, Or are they ethically in the moral right to just purchase it for the $21,000, assuming that is what they are legally able to do? All right, finally we got case 4 here. Serena Hofstadt is a Massachusetts-based professional freelance editor who has a wide variety of clients, including individuals and businesses. One of her clients is a medical association based in Atlanta, Georgia, that publishes a monthly journal. As an independent contractor, Hofstadt edits all of the journal articles, which are complex and require solid knowledge of medical terms and the association's journal style. Hofstadt has lately been inundated with work from several different clients. As a result of her heavy workload, she decided to subcontract the work on last month's medical journal articles to a less experienced friend. The journal's editor calls Hofstadt one afternoon and reprimands her for the poor work on the previous batch of articles. Hofstadt reluctantly divulges that she did not do the work herself and that instead another editor performed the work. Did Hofstadt breach her duties as an agent to the principal in this case? If so, why do you think that? I would suggest looking at whether there was an agency agreement in place between Hofstadt in the first place, and then go on from there to determine whether that was breached or not, and why.